Hi everyone, good morning, good afternoon, good evening, wherever you are. I'm your host, Dr. Haider Shah. On behalf of Calvas, I would like to welcome all of you to this webinar. Thank you very much for joining us. So today we have another very interesting topic, and I'm really honored to welcome and introduce our distinguished guest speaker, who is going to talk about pending the interdisciplinary agenda of contemporary environmental law. So today we will discuss the uncharted territories of a contemporary environmental law, exploring its evolving interdisciplinary agenda and the imminent challenges that demand our attention for sustainable future. So indeed a very interesting topic, and I'm sure you will learn a lot from this session because we have an expert with us in today's this session. So stay tuned because amazing stuff are coming ahead in this session. So before we start, I would like to thank Carlos for arranging such enlightenment sessions for this support and providing us such a wonderful platform. The aim of Carlos is to give you the opportunity to connect and interact with world-renowned speakers, academic leaders, teachers, authors, researchers, experts, professionals, and businessmen to learn from their experiences, recommendations, and suggestions, which will create an impact and will enable you to learn and develop yourself in order to grow and transform individually as well as to contribute to the world in a positive way. As our slogan is come, learn, and share knowledge. So today we have amazing person as guest. He has the great qualities, having a wonderful and vast experience, international known and recognized speaker. We always see him while contributing to the world and field on different platforms. And today we will be taking advantage of his wisdom and knowledge. So let me introduce him formally. He is a dean of the Faculty of Law, Wisdom University, a legal consultant lawyer, UCSM, doctorate in law and administration, Lima, a president of the Interdisciplinary School of DD and FF, Peru. In addition to that, he has more than 100 published in books in the different 15 countries. Last but not the least, he's a wonderful speaker, author, teacher, researcher, professional, and above everything, a great human being. So please help me in welcoming our guest, Professor Dr. Jorge Isaac Torres Manrique. Welcome to the Calvas platform and thank you very much for joining us, Prof. Yes, Prof, can you hear us? Prof, can you hear us? Yeah, I think there is some internet connection issue, and soon Prof will be joining us back. He has a wonderful command on this topic, and I'm sure today we will learn a lot from this session. As you know that we hold different wonderful sessions in order to educate the people regarding the different topic. And this webinar is so important that we have already received so many wonderful questions from around the globe regarding this environmental law. Sometimes what happens is that we are not sure that what are the environmental laws at national level and international level, and how can we be careful regarding that thing. And as I think as a global citizen, we should be knowing that what are the different responsibilities we have towards this planet, and particularly regarding to the environment, because the different SDGs goals, they are more inclined towards the sustainability and the sustainable planet. So I'm sure you people will be knowing the SDGs and following the SDGs guidelines in order to protect the environment as well as the this planet. Welcome back, Prof. Can you hear us?
Thank you very much, appreciate doctor.
Thank you so much.
Excuse me for the interruption, the signal. Very honored and grateful to the invitation to the Center for Academic Learning, Writing and Support Services, and the doctors Sai Haider Shah, General Director. In this opportunity, we talk about the pending interdisciplinary agenda of contemporary environmental law. The global environmental scenario is in a very worry state. This is a matter of urgent, profound, of unprecedented level attention. Therefore, It obligates the states to carry out urgent police, with which represent the adoption of great and essential challenge. The challenges in environmental matters should not be assumed only from the world of law. This is because environmental uses and troubles do not begin and are not adjustable in the viability of the law. Consequently, and the interdisciplinarity analysis is necessary in the present work, the assume this commitment. Thus, they raise and develop the corresponding challenge that must be considered as a dependent agenda. The protection of the environment is a point of utmost importance, given that the world with of threats and new threats are recorded. While it's true that we acknowledge recent and new technologies and coming technologies and smart technologies, it is worried that the great progress of technologies has not contributed decisive to contract its significant way the serious environmental situation of the world. In this use, we unravel and develop throughout its various aspects the challenge that must be assumed to ensure a healthy environmental as well as the realization to the corresponding fundamental rights. By the way of situational diagnosis in, in principle. The end of certainly the existence of a strong relationship between science and law, the creation of disruptive technologies, the influence of social networks, the emergence a new subject of law, the emergence of health, environmental, and economic crisis, and the challenge of the post-agreement environmental uses, the challenge of achieving a fully inclusive and environmental sustainably developed model obligate us to take an in-depth look to develop styles and the light of the really of the 21st century. In this new scenario, growing inequality and increasing pressures of the environmental and natural resource coexist with the emergence of new economic poles and powers, the explosion of new technologies, rapid urbanization, and the great importance of the regional integration spaces, among other signs, in the face of this scenario, and with shaping a better future for all police and actions basis of the holistic vision implied by sustained development are needed. In this sense, I start the challenge first time we have the consumerism. It seriously threatens the environment since it imposes a way of behavior made at consuming products that are harmful to the environmental. However, it's also detrimental to the economic of consumers, since basically it's also a matter of systematic, uncontrollable, and unnecessary purchase. Then we have protections, new subjects of law. This in the understanding that the legal and mainly constitutional recognition of new subjects of law, it's no not Mother Earth nature, among others. Therefore, we aim at the materialization of the effective protection and safeguarding of new subjects of law. Then we have transfer or environmental matters to the courts. Or we can not lose sight of the fact that not infrequently the environmental administrative intervention, either through prevention or sanction, it's not enough to achieve the forcefulness, efficiency, and efficacy that environmental care requires. In this sense, it's urgent that the respective cases be brought to the attention of the judiciality. Then we have principle of greater celerity. However, the observance of the correct environmental protection policy also involves considering the principle of celerity and scarcity, since it's a question of taking actions much more than speedy due to the very important need that this entails. The principle of greater speed must be recognized in administrative and judicial courts. Then we have the legal innovations. We have first time the legal design. Legal design is a human-centered approach that serves to facilitate legal problem solving and promote innovation in the sector. It combines the legal expertise of the lawyer with the insight and methodologies of the designer and the technological potential to create legal systems, services, process, education, environments that are more useful, usable, understandable, and attractive to all. It could be agreed that legal design is an approach that seeks to understand where the crucial flows exist in the system to the moment, to the help make the create leap, definitely with a better system could be. For digital transformation and environmental, we present easy filling fields to avoid unnecessary printing, physical signatures, wasted of time, paper, and research. We create 100% digital documents with all the legal validity you need to make them enforceable. In second time, we have the green nudge. The terms nudge and strategic use are the most common, although the later may also have other definition. Also, when applied the environmental methods in procurement, it means using public contracts to propose environmental several objectives, which make it a genuine promotional activity or nudge. Transversality, however, it's a concept obviously directly related, but with a different meaning. Rather, it refers to the fact that the environmental use cannot be limited to the mere object of the contract, to the fulfillment of center requires, but to the bidders. But on the contrary, it must be present through the entire process and the steps of the contract process. Then we have the new environmental principles, the contemporary milestone typical of the vicissitudes of new technologies and scientific and technology development. It also brings the corresponding adjournments in the various disciplines and science of human knowledge. In addition, The concurrent legal system, not only regional, it's characterized by registered the political constitution. It's a new order of values at the apex of the legal system that is the constitutional state of law. In addition, it should be considered that the law in general is going through a stage of the great reflection and compromise, since we speak of principles as opposed to previous times when rights were the commonplace. On other hand, it's not secret that the environmental is an increasing worrying situation. Therefore, the commitment and challenge of environmental justice become equality acute spectator. The fact is that contemporary environmental law it's not sufficient or sufficient to meet the new demands to the current situation. Therefore, the challenge of achieving a fully inclusive the environmental systems developed model obligates us to examine in deep the styles of development in the light of the really of the 100th century. In this new scenario, growing inequality and price pressures of the environmental and natural resource coexist with the emergence of new economic pools and powers. The explosion of the new technologies, rapid urbanization, and the great importance of the regional integration space, among other signs in this phase of this scenario, and with the wave to shape a better future for all. Police and actions basis of the holistic vision implied by system developed are needed. Therefore, we are of the opinion that it's imperative, very urgent, the recognition of the principle which we propose below. And first time, we have the inclusion, the additional rights. The constitutional developments of environmental protection has meant the consecration of the other environmental rights, among which the rights to access to information participation and justice and environmental matters stand up. In this matter, the Escazú agreement provides certain guidelines and standards that must be present in the constitutional debate. New principles, environmental. In the first place, we have the principle that we have called it the environmental has a higher purpose. This is characterized by prevailing over penalties, determination of responsibilities where a public or private officials. Thus, although it's true that what indicate in this second term is important. It's even more important to pay attention to way is especially relate to environmental preservation and care in the specific case. Then we have also the preventive principle. This principle is characterized by the advanced treatments or protection, that is to say, they anticipate what could become complicated or even irreparable to the environmental venue. Then we have next the precautory principle must be considered. This is based on guarantee environmental protection in the face of eventual scenarios which have not yet been scientifically proven to generate environmental damage. The rationale is the when is done, it is better to take safeguarding actions as a sort of presumed juris tantum in favor the protection of the environment. Then we have next, we bring up the principle of substance development. In this present case, it must be understood that cultural progress in general cannot mean environmental impairment or affection. Therefore, development should be understood youngly. Then we have the principle, the intergenerational equality or equity. This principle establishes the obligation to take a premise that the decisions taken must be focused on safeguarding the future. This is because the right to the healthy environmental does not only belong to the current generation. Likewise, it's necessary to take to consideration the principle of environmental justice. And what must be considered in this respect, it's at the same time the principle of specialization. This in as much is a principle, the creation and the sufficient establishment of the environmental courts is indispensable. It's necessary, but furthermore, they consider that otherwise that it's to have courts, especially in different matters, also hear environmental law conflicts. It's not only not technical, but also violates the fundamental rights of the parties to have a specialized judiciary and to the natural judge. Then we have, in addition, the principle, the progressivity holds that state police must be oriented in a systematic manner, in a continuous, substantial, and gradual advance for the protection and safeguarding of the environment until the maximum levels are researched. To this end, interinstitutional political will is essential. Finally, the principle, the no regression, all which a minimum and non-negotiable level of environmental protection and safeguarding is recognized, but at the same time, it may maintain that there can be no regression in any way in the recognition of environmental regulations. This can also be understood in the light of the principle of prohibition of reform to the horse. It's not only a matter, it's ensure environmental protection, but also of guarantee the legal certainty of no returning to the lower of inferior level of protection than in force. Then we have the essential interdisciplinary scenario. First, we have artificial intelligence. Artificial intelligence is an effective technology system for the application of sustainability in companies and for fulfillment of some to be sustainably developed objectives. Secondly, the tool with the great potential for the application of this artificial intelligence is data science, since it does not accumulate a large amount of data for analysis, but but with the little data, it's possible to make predictions and solutions to sustainability troubles. Some companies, such as IBM, Accenture, Ecopetrol, Coca-Cola, which are in the already make use of some artificial intelligence tools to contribute to sustainability, and this has generated economic, political, and social benefits for the organization to apply it. It can be said that the influence to the expansion of the artificial intelligence in companies for the fulfillment sustainability is of high impact since, according to the theories revived the application of machine learning and data analysis tools allow sustainability to become more tangible in organization. Likewise, this application, the artificial intelligence, allow not only to advance social and environmental benefits, but also economic benefits for the company, and this the evidences in the analysis of companies that have already applied artificial intelligence in other processes. Second time, we have the codification. It's also essential to consider to approve of an international environmental code. This with an objective of strangely the protection, safeguarding of the environment. We have talking about a specialty legal system which does not only register a constitutional recognition. Then we have the governance. This point becomes a first order budget, because in order to have a first-hand knowledge of the place of the fact, it's necessary to consult with to population living in the affected area or the area to be affected. This will provide valuable information to understand and address their specific environmental troubles. Then we have better right to the health environment. Although it's true that there is the well-known constitutional recognition of the fundamental right to a healthy environment, we consider that it's also essential to recognize the constitutional recognition of the best right to a healthy environment. This, and much as the analysis and public policy, must be approached from the primacy of said right above the other fundamental rights. Then we have the training and awareness. That is the implementation, the state policies I mean to include in the different levels of education a subject on the importance and transcendence of environmental law. Then we have the environmental displaced persons, the displacement of people that due to climate change and the subsequent threat or violation of the human rights of the displaced population imposes very important challenge for environmental law and for jurists. For environmental law, there is a need to transform itself and advance in the following of complex legal forms that combine different levels, scales, and institutes. It means then to resemble the current legal forms based on individual rights, and to build legal forms that contain the right and aspiration for all, where life is a priority of protections. For jurists, the challenge proposes legal institutes that respond to new realities, for ethical stances towards life, based on a change of the values that promote solidarity with all forms of life, cooperation, interdependence. It also means promoting space for inter and transdisciplinarity in quarters to seek solution to the trouble of the environmental displaced. The challenge for police and government agencies is to generate the necessary policies and mechanisms so the people at risk or in a situation of environmental displacement do the climate change are attended to the first instance by government agencies, and that they have sufficient legal mechanisms to access to environmental justice, such as access the information, participation in decisions, and access to administrative or judicial instance. Then we have the environmental justice. Environmental justice, in order to achieve environmental justice, a political system capable of offering full and effective democratic participation must be guaranteed, not only to ensure the benefits and rights for the parties, but also to decide in the process where costs and benefits will then be experienced and distributed. This means that within the concept, the environmental justice lies the distributive dimension of the incentives, and this disadvantage with brings the interaction in the environmental use between different individuals and groups. The dialogue between different disciplines and actors that work hard to generate this type and arises or change should focus or have us a challenge to define in different situations that rise and related to environmental injustice. What should be understood by equity and justice, not only for the consequence that fall on those affected, but also for those who directly or indirectly use the natural resource. Besides pondering the mechanism that the countries of scenarios with in which these cases occur to have to stimulate economic, political, and citizen participation. In other words, to study which is the best way towards a fair outcome, which preserves to the protect the fundamental rights of people, the environmental in the long term, and at the same time encourage, sustain, develop, and legal, economic, and political innovation, which essential to address this new challenge. We have the interdisciplinarity. In this item, we consider that environmental use should not be seen only from the word of law. This is because it does not originate or culminate in juridical worries. Therefore, it deserves to be seen also from disciplines and science other than law, such as sociology, psychology, economics, philosophy, among others. Interdisciplinarity, like was the state and private vision and transcendental, but it must be assumed and dialogue cooperate between them. This will result in the best possible way to the expected effective people. Next, we have the reserve climate change. It's necessary to establish an international court which jurisdiction also in climate change, the conversion of public international law into international environmental law, the introduction of institutions that have not yet been considered or that imply the consecration of new and better universal environmental principles. Then we have hazardous hauling waste. In this regard, we bring to the case of damage caused by the export and hards those wastes for the United States of Mexico and for the purpose of holding the exporting companies company level. It's feasible to apply the comprehensive environmental response compensation and liability, retroactivity and objectivity since it was the generator of hazardous substance and because the condition under which the export took place allow the realization of the potential damage that directly affects the territory, the atmosphere, and the consumer of the exporting state. Next, we have the forest loss in the Amazon. In this important that the stage many times the strategic of ensuring the protection of large areas of forest, mainly in indigenous territories, under the mechanism of conditional direct transfer or a payment system for the indigenous people for their commitment to the conservation of this forest. But they also believes that there is a need to move towards more sustainable agriculture. Planning has to be aimed at this. We cannot continue to lose forests, instead to having a more productive agriculture in the same areas that are already dedicated to this activity. There are two troubles of deforestation in some states, illegal logging and the change and land use to convert forests into farmland, a conversion that it's often also so ready and illegal activity. Then we have artisanal mining. The proposal to formalize artisanal mining has been delayed for legal at least 8 years. In December 29, 2 days before to the end 2020, the Ministry the Energy of Mines in use of Supreme Decree that again modified to deadlines of submitting the environmental management instruments for the formalization to a small mining and artisanal mining activities, an indispensable requirement to advance in the formalization process. According to the Minem decree, the deadline to the presentation of the institution for approach or approval was extended in the some case until April the next year. This is an environmental management instrument, therefore it must have the opinion of the Ministry of the Environmental when this line are met through who approach this extension will no longer be a place. We will have new authorities and also possibility is will be extended to infinity, says respect. Next, we have the urgent ratification of the Escazú Agreement. 6 environmentalists were murdered during 2020 in Peru. The last was Jorge Muñoz Saavedra, who had disappeared on Saturday, December 19, after leaving home to go to the forest where to hear a chant show. They there Days later, on December 22, his body was found in the trawling on the Batangray sector in Lambayeque. Muñoz Saavedra had received threats from mafias dedicated to the tracking or trafficking of forest special and the predation of archaeological heritage. We have continuous marine conservations. By 2020, Peru should achieve to the protection 10% of the marine area according to the commitment adopted with the Convention on the Biological Diversity. Also now is Archie targets. This committee also requires ensuring the representativeness for all Peruvian marine ecosystems, taking into account they propose to create marine areas of ecological and biological importance. Then we have final thoughts, the very urgent legal recognition of the environmental principle mentioned preferably in the corresponding code, since in some case its jurisprudential recognition is no enough. All also implies objective, concrete, and timeless actions, both the administrative and judicial levels. This unmatched as would be not would be of no value the materialization of the same when in the practice the simple do not turn out to the apply. Consequently, we consider that more than a legislative modification or the aggravation the penalties for crimes against the environment, it's necessary to recognize newer environmental legal principles, such as, for example, those developed in this paper. In these merits, the training are awareness of the actors in the administrations or environmental justice. Thank you very much for your attention.
Yes, Prof. Thank you very much. What a wonderful speech you have given on this, and you discussed at minute level. I love the way you incorporated all the things right from the technology to the different principles, how they are going to impact us, and how we have to consider back to all these things because on such a wonderful systematic way, because the way you organized it was so nice. One by one, you were explaining. And I love different analogies and I love your examples when you were quoting it. I believe that was a very thought provoking, and I'm sure that our audience from around the globe they would have learned a lot from this because from very versatile way, from very different sources, you actually counted the different thing, and these principles needs to be considered while taking care of the environmental laws and how it is going to impact us and the planet at a larger way. So thank you very much, and really I enjoyed this session with you. And should we start with the first question, please?
Okay, I am ready for the questions about.
Yeah, thank you so much. Yeah. As you also discussed the different challenges regarding the global environmental issues, but the question in detail is the that what are the key challenges in integrating the interdisciplinary approaches within the environmental law to address global environmental issues? Yes, please.
Okay, I consider first of all that countries understand that the nature of the scourge of the environmental crisis does not correspond exclusively to environmental law. Then, to assume that the various sciences and disciplines outside the world of law must be considered. Next, bilateral, regional, and global treaties should be conclude in order to seek a commitment to interdisciplinarity in the environmental challenge. Finally, training and structuring through interdisciplinary public policy. Thanks.
Yes, very nice. And what a wonderful answer you have given in a very precise manner. And as you mentioned in your presentation at the start regarding the role of the technology, but a bit of further that how can we shape the technology, or how can technology shape the environmental regulation, particularly the role of in enforcing the environmental regulation. So the question regarding to that is the what role does technology play in shaping and enforcing the environmental regulation across the different sectors and jurisdictions? Yes, please.
Okay, in this reward, we can cite two considerations. First, big data in order to determine valid information that can serve as wide basics for the origin specific and far research environmental regulations. Second, regulatory compliance in order to adopt a series of environmental protection practice. It's necessary to comply with established national and international standards in order to avoid sanctions, which not only involve monetary penalties, but it's also the loss of corporate imaging and institutional credibility, which translates into a drop in the value of the shares and assets in the market. Thus, this integrity, the strategic management of the business with environmental development. Thanks.
Wow, wonderful answer. And since we have time limitation, one last question we will ask regarding the ethics, that what are the ethical consideration and moral responsibility involved in crafting and implementing environmental regulation on a global scale? Yes, please.
Okay, the right to enjoy a healthy and ecological balanced environment for the development of life is above all a fundamental right. And therefore, I cannot be postponed to different interests such as the concurrent dangerous and gory geopolitics. No? After the enactment of the legal norm, its application in both cases in violation of the environmental international state responsibilities and unavoidable. Thanks.
Hmm. Wow, wonderful, Prof. And the way you are giving answer is so wonderful. Thank you very much. But since we have the time limitation, so we have to wrap up the session. And very quickly, at the end of the session, we ask our each guest regarding their message to the world. So, what is your message to the world as a speaker, author, teacher, researcher, trainer, learner, professional, and educator? Yes, please.
Uh, in principle, the strong presence of new, improved, and future smart technologies and future environmental scenarios. As a concrete example, artificial intelligence can be applied to a wide variety of environmental use. For example, information process through algorithms can generate inputs to improve resource management, support decision making for land use and land management. Artificial intelligence systems can help make agricultural system more efficient, reduce food waste, fertilizer application, and water use. Artificial intelligence can also help model vulnerable ecosystems, predict weather patterns, and project future climate change or events. It can support the monitoring of natural resources such as forests, help against deforestation, among many other examples.
Wow, wonderful. Thank you very much, Prof. And that brings me to the end of this session. And to the audience, that please do follow our work, and you can email him and guidance. He is very generous and always ready to help the people. So that's all we have time for today. And thank you once again, Professor Dr. George Isaac Torres. And I would like to thank our audience who joined us. If you have any additional questions about information shared today, please email us or connect to the speaker directly through his email or social media account. Thank you all for your support and liking our session. Stay tuned as many sessions are on the way. Please do not miss any session. Until next session, take care of yourself. Bye-bye.
Thank you very much.